Okay, this is review video number 8 on the Supreme Court. Courts do solve collective dilemmas for us. In particular, they solve prisoners' dilemmas between individuals who want to be able to trust one another and transact, but can't. And so one of the main things that courts do is it enforces contracts. The courts also check the other two branches of government. They can declare executive orders and legislation from Congress unconstitutional. How does a court, though, decide whether a piece of legislation is unconstitutional or not? Well, first there's a process involved, right? There's got to be a court case, so the court can't just butt in after a law has been passed. There has to be somebody who has standing to sue and who's been hurt by the law. Then at least 4 judges have to agree to hear the case. This is what we call granting certiorari, or granting cert for short. After that, the parties have to submit written briefs to the court, and the court will listen to oral arguments and read amicus briefs from other interested third parties. Once the court's made a decision and retires into conference and makes a decision, then the Chief Justice will assign the opinion in the decision if he happens to be in the majority, and if the Chief Justice is in the minority, then the senior member of the majority will decide who writes the opinion. That's the process-oriented stuff. But how does a justice know whether a piece of legislation is unconstitutional or not? Well, there's different theories about how judges behave and how they ought to behave. Originalism is the idea that a judge should interpret the law or the Constitution by looking at what the provision meant when it was adopted. So what did it mean to the people who wrote it? On the other hand, we have loose constructionism, which basically asks what the best way to understand this provision is given the overall purposes of the document. Right? So you look at the best way to understand it, not based on what the people who wrote it thought, but based on what you think the overall document is meant to do. And that gives judges a little bit more latitude in changing the meaning of provisions if new circumstances arise. The doctrine of stare decisis is the idea that unless there's a very compelling reason to reverse a decision, current decisions must be consistent with past decisions. This stare decisis is very, well, actually, no, it's not that related to judicial activism and judicial restraint. Judicial activism is when the court stands in the way of legislative intent, and this is sometimes associated with substantive due process, but the idea is that the court is going to be active in denying the legislature the power to legislate the way it wants. Judicial restraint, on the other hand, is the tendency of judges to defer to legislatures, and this is often associated with procedural due process, where judges take a more humble approach and don't contradict the will of the legislature. Which brings us to the question, how much power do these judges have anyway? On the legal model, stare decisis is really powerful. Precedent is really constraining, and the judges do not have a lot of wiggle room to insert their own views. At the other end of the spectrum, you have the attitudinal model, which says that judges have a whole lot of discretion, at least sometimes, that you can find a lot of different precedents for different types of rulings, and language is easy to twist if you try hard enough. And so on this view, the decisions of judges depends a whole lot on their political attitudes and ideologies. And finally, you have a third model somewhere in between, which is a strategic model, and that says that what a judge's view will be and how much power he has or she has depends a lot on the view of the rest of the court. That is to say that a judge will try to articulate his views and his decisions based on his ideology, yes, but also based on trying to build a consensus with other judges. That is to say, it's not only your ideology that matters, but it's the ideology of at least a majority of the court, so typically 5 justices. And so you're going to orient your views and your arguments to a position that you think can sustain a majority.